Good afternoon, everyone. Thank you for joining us live for Legal Services of Eastern Missouri's presentation on special education and COVID-19. We are co-hosting this presentation with the St. Louis City Mental Health Board. My name is Amanda Schneider, and I am the managing attorney of Legal Services of Eastern Missouri's Health Justice Initiative and our Education Justice Program. I am joined by Maggie LaMore, the program director of the Children's Legal Alliance, who will be the lead presenter today. Michelle Weltman, staff attorney with the Children's Legal Alliance, and Dan Underwood, managing attorney with the Children's Legal Alliance, are also behind the scenes helping with responding to your comments and questions. Note that our presenters cannot see your questions here in the chat, but if we have enough time, we will be answering questions at the end of the presentation. A recording of this video will also be available on our Facebook page after the live stream ends. Additionally, the slides from today's presentation will be available on our Legal Services of Eastern Missouri website. Please also note that unfortunately, we are unable to give specific legal advice in response to questions and comments in the chat, but feel free to call our intake line at 314-534-4200 to see if you are eligible for legal representation from Legal Services of Eastern Missouri. Now I will turn the presentation over to Maggie LaMore.
Thank you, Amanda. As Amanda said, welcome to our presentation on special education and COVID-19. The information contained in today's presentation is current as of today's date and is based on guidance from the U.S. Department of Education and the Missouri Department of Elementary and Secondary Education that came out in March of this year when all school districts in Missouri transitioned over to distance learning. And so because the situation with COVID-19 is ever changing and ever evolving, guidance from the U.S. Department of Education and DESE could change by the fall. So today we'll be talking a little bit briefly about legal services and what we do in case you are interested in legal services representation for special education or another area. We'll be talking about the special education landscape and guidance during the current school closures, some advocacy tips for parents during this time, a little bit about Section 504 plans and how those tie into COVID-19, and then we will have some time for questions and answers at the end of the presentation. If you have questions during the presentation, please drop those in the Facebook chat, and then we'll try to answer as many as time permits at the end of the presentation. So first, Legal Services of Eastern Missouri is a Legal Services Corporation funded program. We provide free civil legal assistance in the St. Louis area and northeastern Missouri. So that includes in our broadcast area, St. Louis City, St. Louis County, St. Charles County, and Jefferson County. If you are watching this presentation and you are not from the St. Louis area, feel free to contact a legal aid organization or legal services program in your geographic area to see if they're able to provide educational legal assistance as well. Legal services provides civil legal assistance in a number of different areas: family law and domestic violence, public benefits, Medicaid, education, immigration, and newly unemployment. So if there are other COVID-19 related concerns that you're having or civil legal concerns that you're having in general, please feel free to contact legal services at the numbers below to see if you qualify financially for our assistance. The two programs that are represented here today are the Children's Legal Alliance, or CLA, and the Education Justice Program, or EJP. Both work with families to provide free educational legal assistance. CLA does direct representation for families. We're very fortunate to be funded by our co-host, St. Louis MHB, to provide targeted legal services in the city of St. Louis, as well as social work support in the city of St. Louis, but we do provide legal support throughout the St. Louis area. And the Education Justice Program is able to provide support on impact education issues, and they're really targeting the root causes of education inequity throughout the region. Thank you. Some of the main cases that Children's Legal Alliance assists with are special education, So obtaining special education testing or services for students, making sure that the IEPs that are written are appropriate for students, that they're able to make progress. And for those students who are not receiving the services in their IEP as written, working with those families to advocate with the school district to make sure that those services are provided. We also work with families to obtain and implement Section 504 plans with schools. Again, I'll be talking about that a little bit later. We also work with families on school discipline issues. We attend discipline hearings, suspension, expulsion hearings, and we also advocate for children who have been excluded from school who have not been officially suspended or expelled. And we also work with families experiencing homelessness to ensure that their children are able to remain enrolled in school and provided transportation through the McKinney-Vento Homeless Assistance Act. So now we're going to talk about special education during school closures, what that looks like, and some of the recent federal and state guidance that has come out. So first, the centerpiece of what we talk about when we talk about the word special education, we're referring to students covered under the Individuals with Disabilities Education Act, or the IDEA. And the IDEA at its core entitles children with disabilities to a, quote, free appropriate public education, or a FAPE, from birth to age 21. So what exactly is a FAPE when we say that? So a free appropriate public education means special education and related services provided at no cost to the parent, designed to meet the unique needs of each child. And so to actually meet that FAPE obligation, a school district creates an IEP, which is a legal document setting out the specific services the child needs to receive. And those services must be reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances. So that's basically legalese for saying the IEP must provide services that are going to ensure that the child is going to make progress. And so if the child is not making progress, the services in the IEP should be changed or updated to make sure the child is able to make progress moving forward. So special education is always a little bit more of an art than a science, and we work with families all the time on making sure the IEPs are appropriate, but moving quickly to distance learning has been a struggle for a lot of people. It's been a struggle for a lot of parents, and it's been a struggle for a lot of teachers and districts to be able to adapt very quickly to a changing school environment. So the main thing that we know in terms of what districts are required to provide is that if a school district provides distance learning during school closures to all students, and that includes sending home work packets, it doesn't necessarily need to be formal, distance online learning, the district is required to continue providing special education services to students with IEPs. So that means providing the services listed to the greatest extent possible. And so how can you tell whether or not those services are being provided to the greatest extent possible? Amanda, can you go back, please? Thank you. That means really taking a look at your child's IEP goals, taking a look at your child's IEP services and saying, no matter how these services look right now, are the goals in my child's IEP being addressed? And are those services being offered in some way, shape, or form to allow my child to make progress in those areas? And this includes extended school year or ESY services, which is basically special education summer school for those students who experience significant regression over long breaks. And so even if summer school is not being provided, ESY should be provided, even if it's virtual. Now, the one time when districts do not need to provide instruction is when they're providing no instruction to any students. So for example, St. Louis Public Schools decided to completely close its doors for 2 weeks after spring break in March in order to figure out the distance learning piece. And so for those 2 weeks, no students were receiving services. And if any other district decides to change their school calendar and school early before the calendared last day of school, then the services for special education students would cut off on that day as well. And really, when you're thinking about distance learning and special education, one of the the first thing you really need to worry about is having access to technology. because so much distance learning is taking place online that without an iPad or a Chromebook or a laptop or internet, it's going to be really difficult to access the appropriate special education services via distance learning. So if you have not already received technology from the school district, making sure that, especially moving forward for things like summer school, and if this happens again in the fall, if children are sent home again in the fall, making sure that your child has access to the right technology in order to be able to do distance learning at home. And I know that can be difficult in communities where not everyone has internet. In rural areas where you may not have good, consistent internet or self-service, and that is something that that is difficult and that districts will need to work around in order to provide services. And also, like it says on the bottom of the slide, students who have assistive technology devices at school should also have access to that at home during distance learning. So for distance learning, and this isn't something that I've seen a lot of districts do, but it is definitely recommended by the state of Missouri and other states. And there is a sample form for distance learning plans on DESE's website, and that's linked below and should also be linked in the chat. So the state recommends that IEP teams consider including a distance learning plan in a child's IEP. So that's not an amendment to the IEP, it's just kind of an addendum form saying, okay, if there is a school closure, how are we going to provide services and how are we going to ensure that this child is continuing to receive a free, appropriate public education? And the advantage to actually sitting down as an IEP team and discussing the distance learning plan is it ensures that the parent and the school are on the same page about what the services are going to be and what might work for the child, so there isn't a surprise on either end when school closes. And so even when school reopens in the fall, I would encourage parents to bring this up to their child's IEP team and say, hey, if this happens again, if we have another spike in COVID cases and we have to close school, what are we going to do to make sure that my child is receiving appropriate services? And so in terms of what's actually happening during this time, IEP meetings are still happening via Zoom, via video chat, because schools are still required to meet the timelines for IEPs if possible. So the timelines that are laid out in by statute and in state and federal regulations have not been waived. So schools are still required to meet those timelines. So they can hold IEP meetings via phone or video conference if the parent and the school agree. Now, if you as a parent do not have the technology or are not comfortable having the IEP meeting via video conference, you can say, I want to waive the timeline. Let's wait until we can meet in the fall when everyone can meet together. Or is there a way for us to try to do this differently, maybe socially distant, to be able to meet current public health guidelines, but be able to do this in person? And again, that'll depend on state, county, and school district policies with respect to social distancing and public health. The one thing that may be extended are special education evaluation and reevaluation timelines. So if a child is actually being evaluated, if they're having to do IQ testing or academic testing for a child, or having to do behavioral observations, those evaluation timelines may be extended because it can be difficult, and I'm not sure whether school psychological examiners are allowed to or should do those types of testing via video conference with students, especially those students who may have some attention difficulties. I personally would have concerns about the validity of testing that was done via video conference, unless there's something that actually changes with those professional organizations. If professional organizations come out with some guidance saying that it's okay for psychological examiners to conduct testing via video conference, then that may change. But at this point, that timeline for evaluation will be extended. And the other important thing to remember, if you had concerns with your child's academic performance, if your child did not have an IEP prior to the COVID-19 school closures, initial special education evaluation requests must still be accepted. And again, as a reminder, can you go to the next slide, please? Thank you. The timeline for the IEP process, if a parent requests or makes a request for special education, you should do that in writing. The district has 30 days to respond and either 1, schedule a meeting to decide whether or not to test, or 2, provide a written explanation of why they're not going to test. And that still needs to be done within 30 days. So the one timeline that is kind of in flux at this point, like I said, is that 60-day evaluation timeline, because it can be difficult to do some of those evaluations in person. But if a child has already been was already evaluated prior to COVID-19, the test results can be reviewed via a video call, and then the IEP meeting can be conducted via a video call. And I've been able to do that for multiple clients while this has been going on. So the one thing that can and should be delayed is just that testing timeline. So some advocacy tips for parents during this time. One of the main things to do during this time is making sure that there is documentation and communication. So documenting the services that the school is providing to your child during the school closure. Keep a calendar of how often the child is having video conferences with a speech therapist or an occupational therapist or a special education teacher, communicating with the school about what is working and what is not working with your child during distance learning. And with that communication, making sure that communication is in writing as much as possible, using email and text to talk to school staff. And that in some ways can be more convenient for both you and the staff, especially because staff may be home with their kids and may be teaching during the day. You may be home with your kids during the day. If you're emailing, you're able to get the information back and forth without having to worry about, is this person busy right now? If someone does call you, either take notes after the phone call or follow up after that. And this documentation, the importance of having documentation and communicating, it's important in general, just as a parent, to keep those lines of communication open, making sure the school's aware of what's working and what's not working. And also for you to make sure that you're letting them know, that they're on notice if you have concerns about your child's services. Because special education services during this time may look a little bit different, but children should still be receiving those services. And then lastly, making sure that you're writing down observations about your child's academic and behavioral progress or regression. Behavior may be different during this time. Academic progress may be different during this time, for a lot of different reasons. Some related to what the school is providing and some not related to what the school is providing. One interesting thing to think about with behavior is if your child's behavior is improving, it may be that school actually is a trigger. And so removing that school environment as a trigger may actually improve your child's behavior or improve your child's performance. So that's something to look at and to note as well when you're going back to school in the fall, to make notes about whether or not your child did better or did worse in this particular environment. So when school resumes, and again, this is, a when, not necessarily an if, but a when. For now, I know that most schools are doing summer school via distance learning. I'm not sure about when schools come back in August, but when school does resume, whether it's virtual or in person, asking for an IEP meeting. Because especially if this is in person, if we're trying to go back to business as usual, the child may need additional services or compensatory services as a result of the prolonged school closure for this spring. So what compensatory services are, and you can look at it in a couple of different ways. So compensatory services are special education services that are provided to make up for the services that were lost during the school closure. And so when you're thinking about compensatory services, you can look at it as, okay, I'm going to ask for an hour for hour, makeup of what was missed. So how many weeks was school out? How many minutes of service did my child miss? But really what the IEP team can and should be looking at as well is how much progress was made or lack of progress was there during that school closure. Did the child regress during the school closure? So, it may not necessarily be a minute for minute, type of calculation. The child may need more services because there may have been regression, not even just, staying stationary at where they were before school closed. And another thing to think about there, if your child's behavior has improved at home, like I said in the previous slide, not assuming that the child may need less services, less academic or less behavioral support when school resumes. It just means that the home environment may be different than the school environment. And so thinking about, ensuring that what was provided in the school environment is still provided, because some of those behaviors and some of those concerns may return once the child is back in a larger classroom setting. So a brief discussion on Section 504. And again, like I discussed with IEPs, this is not going to be an in-depth conversation on Section 504, but more how it specifically applies to COVID-19. So Section 504 of the Rehabilitation Act is somewhat similar, but somewhat different to the IDEA. So Section 504, instead of making sure that a child with a disability is able to make progress in educational services, Section 504 prohibits disability-based discrimination and is really an access statute. So students with disabilities must be given equal access to the same programs and services as their non-disabled peers. What that means is basically if a child doesn't have an educational issue that would require specialized instruction like special education, but may just need accommodations for a medical condition, then Section 504 would apply. So like I said, it's a non-discrimination statute. And the way you would determine whether someone qualifies for Section 504, there must be an impairment that substantially limits a major life activity. So again, this does not have to affect learning. It just has to affect some sort of, body system or life activity. And this includes mental health diagnoses that don't necessarily impact, like if ADHD doesn't impact a child educationally, but the child still may need frequent breaks or accommodations, that would apply as well. And so the school provides accommodations and modifications through a 504 plan. So with COVID-19, how Section 504 might apply for students who may not have had a 504 plan before, for those students who have compromised immune systems, who may have been okay to go to school previously without accommodations. If you as a parent are concerned about, whether your child has an increased susceptibility to COVID-19 when school returns, and wondering what that's going to look like and making sure that your child has appropriate protection, I would say seeking a your child's doctor's recommendation about what your child needs to make sure that they are able to be healthy and safe in the school environment, or whether your child needs to continue to stay home for a few weeks or months if there's another COVID-19 outbreak. So in order to do that, I would get a specific letter from the doctor saying what specific recommendations or safety measures are recommended when school resumes. And that could be anything from making sure that other people are wearing personal protective equipment at school, making sure that there are particular cleaning procedures that the school undergoes. And I've seen this in the past for immunocompromised students who are, recovering from chemotherapy and things like that, who may need increased cleaning procedures at school. And this just students who may not have had a need that has risen to the level previously, but they really do need to make sure that their health is considered. All right, so we are going to, I'm going to turn it back over to Amanda to go through some questions from the chat, and she and I will both be answering questions as long as time permits.
Thanks, Maggie. And we do have some questions that have come in. So is a parent able to get a Section 504 plan for a non-COVID related issue?
Yes, absolutely. So like it says on the slides, a student may qualify for a Section 504 plan if there is a disability or if there's an impairment that impacts a major life activity. And so 504 plans were in wide use prior to COVID-19. This was just a suggestion for if there is something that's COVID related that needs to be addressed right now.
Thank you, Maggie. And the next question we have is, what are you hearing about summer school programs or extended school year programs for this coming summer for students with disabilities or students in St. Louis generally? And it might be helpful for the listening audience for you to differentiate between the two. But is a school district still required to offer these programs for the summer?
Right. So summer school in general, districts are not required to offer summer school to all students. And so the difference between summer school and extended school year, many special education students will just engage in regular summer school. But for those students who show significant regression or losing progress over long breaks like summers or holidays, those students may require special education services for a longer period of time over the summer in order to make sure that they aren't losing as much ground come fall. And so that basically looks like special education summer school. But in those cases, if extended school year is in your child's IEP, then your child does need to have that extended school year, that sort of summer school type program. For general education summer school, it's my understanding, and I work mostly in the city, that St. Louis Public Schools is doing high school summer school virtually over the month of July. Elementary and middle school is in the month of August, running up to the start of the school year. I know some charter schools are running extended school year virtually over the summer. And Amanda, I'm not sure what you've heard about special school district or the component districts in the county about that.
Right. So I have been hearing, yes, for example, SSD or special school district is holding extended school year virtually for a few weeks this summer. So that's what I'm hearing on my end. So the next question that we have is, what if a parent cannot participate in an IEP team meeting remotely? And in particular, Maggie, I'm thinking about those clients that we work with who have minutes phones, phones that run out very quickly, those that cannot stay on the phone for a long meeting. For, an IEP meeting lasts at least an hour if it's a good IEP meeting, probably. What are your thoughts about what the law requires in those situations?
Yeah, I mean, so the law is clear that schools must try to ensure, parent participation and really try to work with parents on making sure they're able to participate. So if a parent, say, wants to have a phone meeting but has a minute phone, maybe assisting the parent with making sure they're able to get additional minutes, or saying to the parent, okay, we can wait until we're able to meet in person again in order to have the meeting. And again, even if school's not in session, if they're able to abide by current social distancing guidelines and maybe sitting in a room far away, but everyone wearing a mask, that could be something that could be done as long as it's not, there is that public health consideration, and there is that balance that needs to be done in terms of what's done virtually and what's done in person. But I think schools do need to work with the parent to make sure that it's not just video call or bust. If you can't be part of it, you can't be part of it. A parent, absolutely, if a parent wants to participate, they have the right to participate. The school needs to, do what they can to make sure the parent can participate.
And I agree. And I would stress that really the IDEA requires that an IEP meeting should only be conducted in the absence of a parent if that school district is unable to convince the parent to attend. So I think that's really strong language that supports everything that you suggested, Maggie. So the next question is, what if a parent requests testing for special education now? I think you hit on this a little bit in your PowerPoint, but can you elaborate? Like, what is that process? What should be happening?
Right. So what should be happening is, and of course, what has happened in the past, depending on the district, isn't always what should be happening. But what should be happening is when a parent makes a request for special education, and again, if you're making an initial request, trying to put it in writing, sending it to the principal and the school counselor, saying I'm concerned about my child's performance in these particular areas in school, and I would like for them to be tested for special education eligibility. And the school district should respond by saying, okay, we've reviewed the referral. We're going to go ahead and schedule a meeting to consider whether or not we're going to test, and they should do that within 30 days. Or the other option is saying, no, we're not going to test, and actually providing a written response called a notice of action. It's like a one-page response in legalese, saying here's why we're not going to test. And you as a parent do have the option to appeal that decision, because you do have the right to disagree and say, no, I do think my child needs to be tested. And if you receive a notice of action saying we're not going to test your child and you disagree with that, I would recommend trying to get in contact with an attorney or a lay advocate to try to figure out what you can do to try to get your child tested. One of the wrinkles with the current, COVID-19 related school closures is that when you're looking at data to support whether or not your child should be tested, you really do want to look at everything that happened before the current school closures, because it is hard to take good data while school is closed. And so, if your child had been making good progress while in school and isn't making good progress right now, there may not be enough data to support special education testing. But if there were concerns while school was in session previously, that's really what you want to take from in determining whether or not there'd be a reason to test.
And I think I have one more question, Maggie, especially because what we're dealing with now in the time of COVID is accessing remote learning and needing that technology to access that remote education. Can a parent ask, especially for a child with a disability who ordinarily requires assistive technology as part of their IEP, can a parent also request that be made available during this time of remote learning?
Absolutely. I think the guidance is pretty clear from what I've read, that students who have assistive technology should be able to access that at home as well. Especially if you're talking about, for a child who's nonverbal and there's an iPad or something that actually talks for that child. If the parent is having to do a lot of, some of the teaching at home, or if the child is, say, working with a speech therapist via video, there's really no way for the child to be able to adequately do the schoolwork without some of that assistive technology. So absolutely, I would say the school should make that available for the parent. And for many clients, assistive technology devices, schools tend to get those are able to get those paid for through the client's Medicaid or health insurance. If the assistive technology device is paid for by the client's Medicaid or by the client's health insurance, that AT device actually does belong to the client, and so definitely needs to be able to go home with the child.
Thank you, Maggie. I don't think we have any other questions right now, so I just want to say thank you again to everyone for joining us today for our Legal Services of Eastern Missouri and City Mental Health Board Facebook Live presentation of special education and COVID-19. Just a reminder again that the recording of this video will be made available on our Facebook page under videos after the live stream ends. Additionally, the slides from today's presentation will be made available on our website. And our next presentation in the Facebook Live series will be on Thursday, May 21st at 2 p.m. And that presentation will be on Missouri Medicaid and other healthcare options in the time of COVID. So thank you again, everyone, for tuning in.